Good afternoon and welcome to our third webinar on the Employment Rights Bill. We're going to do some more of these in the new year, but hopefully by then it'll no longer be the Employment Rights Bill, and frankly we're just going to have to find something new to talk about. But anyway, if there's something you want us to cover in a webinar in the new year, just drop us a line, let us know, and we'll see what we can do. So, to begin with, as ever, of course, there is always the inevitable disclaimer that nothing I'm saying today should be taken as legal advice. These are my opinions. They are my own opinions. They hopefully align with those of the union, but they are my opinions. And look, if you've got any doubt or any questions about any of the stuff that we are going to cover today, then really your sort of starting point should be your local rep or your union officer as appropriate. And look, just on the subject of questions, if you have any questions as we're going along, please try and use the Q&A box to put your questions in. Use the chat field if the chat is working. I think yes, chat is working. So you can put whatever you like in the chat, but we're going to look to the Q&A box for questions. It just makes it easier for us to identify any questions that people have got as we're working through. So yeah, hopefully all that makes sense. Now, I know that there's a lot of people had signed up for today's session, so that's fantastic. And I also know that a lot of people who signed up today have been on previous webinars, but also quite a lot of new people today. So, you know, you're all very welcome, whether this is your first or your third. If it's your third, thank you very much. If it's your first, we'll hope to see you again. But if you haven't seen the first or the second webinar in this series, then what we'll do is a quick kind of recap, but a very quick recap of what I talked about in the first and the second webinar. But if you want to go and watch them, you can watch them. They're on YouTube, but you need the link to find them because they're not searchable. So if you haven't got the link and you'd like the link, just get in touch and we will send you the link. So what did we talk about? Well, we talked about the fact that the government is saying that this is the most significant upgrade of workers' rights in a generation. The government's had what it calls the Make Work Pay plan, and the Employment Rights Bill represents just the first phase of that Make Work Pay plan. So there will be more stuff to come in due course, but this is probably the biggest chunk of it. There's a huge amount of time and effort gone into producing this bill and getting it through its parliamentary process. But yeah, we'll see what else is to come in the future. So we also talked about the timetables, both for consultation and for implementation of the Act. And the reality is that's going to be across a sort of 2-year period with some key stages for implementation of the changes that are coming. The key stages being some stuff just after royal assent, just after the bill becomes an act. Some more stuff within a couple of months of there, and then April and October next year, and then probably April and October in 2027. So we'll see how that all pans. Some of the consultation exercises are already ongoing now. So, you know, if this is any of these changes are in an area that are particularly of interest to you, you might want to have a look at some of those consultation documents and see if you can, you know, feed into those and share the views of yourself and your members. So we also talked about the proposed changes to the law around balloting and industrial action, the fact that we're going to see finally implemented electronic balloting, hopefully, for statutory ballots, whether that's for elections or for industrial action balloting. So that should be good. We'll see when that comes. We talked about extension of protection, both from dismissal and detriment, for workers taking part in industrial action. So again, that's going to be I think, really useful for us to see that, so protecting workers' rights to take part in that industrial action, and removing the incentive for employers to simply wait out, a period of 12 weeks and then threaten to dismiss people for continuing to take part in the action in the hope that the strike collapses. We've seen that tactic deployed before. And we also talked about the plan to change the default position on political funds as to whether people are by default opted in and then need to express a desire to leave, or whether people need to express a desire to be in the political fund in the first place. What else did we talk about? Well, day one rights to sick pay and the removal of the lower earnings limit for qualifying for sick pay. Now, that lower earnings limit is a reference to national insurance contributions. And I talked, I think it was in webinar number 1, about that removal of the link between the lower earnings limit and qualifying for sick pay, which I think is quite a progressive thing. We talked about the introduction of day one rights to paternity and parental leave, although it remains to be seen whether those day one rights are to paid or unpaid leave. Again, time will tell on some of this stuff. Also talked about the change of the maximum value of protective awards. And I've just been reading today one of the consultation documents on whether the government should introduce interim relief for people who are dismissed as part of a collective redundancy consultation without the employer going through the proper consultation process. And the government ruled that out fairly early on in all of this process. So although they're keeping it under review to see whether some of the changes that are coming will, incentivize employers to comply with their obligations more fully than has been the case in the past. We also talked about simplification of the statutory recognition process, the ban on fire and rehire, and new duties on employer to prevent sexual harassment in the workplace. So today's focus is going to be on really the sort of final stages of implementing the Employment Rights Bill. You see the screenshot there, that's the front page of the government's roadmap document, which all these documents are available online if you're really interested in this stuff and you want to see what the plan is. But of course, this was produced in July, and a number of things have changed since July in terms of what the bill is currently saying, as we will see shortly. So today we're going to be focusing on the final stages, which will be coming in 2027. Now, at the moment, the plans are that we will see gender pay gap and menopause action plans being a requirement, although they're going to be introduced on a voluntary basis from April next year. We're going to see strengthened protection from dismissal for pregnant workers and new mothers. Now, in terms of the detail of that, again, some of these things are subject to secondary legislation, and there'll be ongoing consultation about when should that protection begin and end, and the government seeking views of unions and employers on these issues. But the thinking is that the protection will end maybe 6 months after the new mother returns to work. The government's also seeking views on whether similar protections should apply to other parents taking statutory leave. So whether that's the spouse taking shared parental leave or paternity leave, or whatever it might be. So again, more consultations and more details to follow on this stuff. There's going to be regulations to come about what counts as reasonable steps in preventing sexual harassment. And, again, it's not going to be, I would imagine, an exhaustive list of what would constitute reasonable steps. So if you haven't done the things on the list, then you've failed to take all the reasonable steps. That may not be the case, because there may be things on the list that just simply don't apply in your workplace. So if the employer hasn't done it, then is there going to be a case there that we're running off to the tribunal with? I don't know. We're going to have to wait and see. There's going to be some extension of the law around blacklisting. We're going to say a little bit more about that in a moment, so I won't say any more just now. And the roadmap document also says that coming in 2027 is the industrial relations framework, whatever that is. I say whatever that is because I'm not clear what that is. And the reason I'm not clear about what that is because the words industrial relations framework simply do not appear in the bill. Each of those words is in the bill. The bill talks about industrial relations. The bill talks about frameworks. But it doesn't put those two concepts together in any one place in the bill. So exactly what's coming in 2027 as far as an industrial relations framework is concerned, I have absolutely no idea. If any of you know, please drop us a line in the comments. So other things we're talking about will be regulation of umbrella companies. Now, some of you may be very familiar with what an umbrella company is. Some of you may have absolutely no idea, but an umbrella company basically is an agency that provides quite often payroll facilities for people who are working for and under the control of a third party, so a client. In other words, agencies. Umbrella companies are a type of employment agency. And the plan is in 2027 to extend some of the existing agency worker provisions and protections, etc., to people in those kind of employment relationships with these umbrella companies. The view from some of the consultation documents is that these umbrella companies are being used as an attempt to maybe to bypass or to get around the employment rights and the obligations to those workers in those relationships. Collective redundancy consultation thresholds, I think, is going to be an interesting thing that we're going to need to pay some attention to when we get to it, because the bill talks about removing the requirement that 20 or more dismissals from one establishment are contemplated within a 90-day period. The 90-day period thing I don't think is going to go, but the one establishment point is definitely going to be changed. Now, I think this is something potentially could be quite challenging, that if you work for an employer that has discrete pockets of activity discrete pockets of activity across different parts of the country, then if something is happening in Bognor Regis, what relevance does that have to something that's going on in Bradford, for example? Well, we need to see the detail of how those collective redundancy consultations are going to be conducted to work out what the answer to that question is. So at the moment, it's kind of far from clear. So we're also going to see some changes around flexible working. Again, these things are all going to be subject to consultation, I think, because with flexible working, it's always pretty easy for an employer to decline a request for flexible working. But the bill talks about moving to a position where the default position is that a request should be agreed unless there's good reason not to. Is it going to make any difference in practice? Maybe. I mean, flexible working, I think we'd all agree perhaps that where we are now in terms of people's working relationships is very different to where we were sort of 7 or 8 years ago prior to the COVID pandemic. That certainly I know of colleagues who work from home now where that wasn't a thing in 2019 or 2018. So yeah, we need to kind of see whether the legislation keeps up with that, or whether it is able to reflect what I think has been a sort of culture change across the world of work for many businesses. Some changes coming around statutory bereavement leave. I think that's always going to be an interesting thing. How close does somebody need to be to the deceased person in order to qualify for statutory bereavement leave? Again, there's going to need to be some detailed work through on that. There's been quite a lot of backwards and forwards between the House of Lords and the House of Commons in this sort of parliamentary ping-pong process that we're still stuck in around 0 hours contracts and workers' right to have an offer made to them of guaranteed hours. The Lords are pretty entrenched in their view that a worker should request the offer of a guaranteed hours arrangement, and that the Commons view is no, workers shouldn't have to request that, employers should have to make the offer. Well, again, this remains unresolved as between the Lords and the Commons, but maybe we're getting closer to seeing some agreement on that as well. And of course, the other thing that the roadmap says is coming in 2027 is day one right to protection from unfair dismissal. Now, I know some of you will have seen the press in the last week, 10 days or so, around this, because, hang on, day one unfair dismissal, yes, that was the plan. But on the 27th of November, last week, the government apparently changed its mind. There'd been meetings held between ministers and apparently trade union leaders and business leaders and employers' organisations and such like. And the government has accepted the Lords' proposed amendment that all of that stuff around statutory probationary periods, light touch dismissal procedures, not that we had any of the detail of any of that, and that was all going to be subject to consultation and further secondary legislation, regulations. All of that is gone. I know what we're going to have instead is a move from a 2-year qualifying period to a 6-month qualifying period. And as I say on the slide there, that plan is at least fairly simple. It doesn't mean that we have two different arrangements and sets of rules around how people can be dismissed depending how long they've worked there. It's simple. The existing law just applies from 6 months instead of from 2 years. So the question then becomes, why should we have to wait 2 years for that change to come in? Well, it seems that we might not have to wait for that long, because literally as of yesterday, I was hearing reports that apparently there was a piece in The Guardian saying that Angela Rayner is going to table an amendment to the bill because, as she points out, there is no need for consultation, there's no need for secondary legislation, that the new qualifying period should therefore simply be introduced sometime next year. I think that is a good idea. I think potentially, though, we're going to see a lot more people ending up with potential claims for unfair dismissal. So if I had to make a guess, is it going to come in next year? Maybe October next year? Maybe April next year might be too early. But yeah, I think they might go for October next year. I don't know, we'll have to wait and see. It's all very exciting, this, isn't it? Yes, it is, yes. Yeah. So I thought it might be worth just talking a little bit about blacklisting, because this is a topic which is quite a sort of complex area of law, really, and it doesn't apply all that much in very many sectors, other than hugely and somewhat notoriously in construction. A little while ago, so 10 years ago, the union was running claims on behalf of a lot of members in the construction industries who'd been affected by an enormous, scandalous blacklisting exercise being done by an organisation on behalf of several very high-profile very well-known construction companies. And that organisation was compiling lists of union activists, people who'd been involved in, the sort of straightforward things like, being branch officials or workplace reps, through to people who'd organised, wildcat strikes or even official industrial action and all of that. And those companies were using this third party to effectively vet new potential employees and use the information that was being held about these people in order to decide whether or not to offer jobs in the construction industry on various projects and such like. An absolute outrage, and it was a piece of work that came to light because the Information Commissioner's Office got a warrant and executed this warrant and went and visited the premises of this organisation and seized huge amounts of documents. But the warrant didn't cover everything that the organisation had. And what the warrant didn't cover, while the staff of the Information Commissioner's Office were busily removing the documents they were entitled to under the warrant, allegedly the people who worked for this third-party organisation were out in the backyard busily burning every other piece of paper they could lay their hands on. So absolutely appalling, and the scope of that blacklisting activity, we'll probably never know the full extent of it. But it is, as I say, a fairly complex area of law, and at the moment, blacklisting is the practice of compiling information on individuals concerning their trade union membership and activities, and this is the crucial bit, with a view to that information being used by employers or employment agencies to discriminate in relation to recruitment or treatment. Now that is taken from the explanatory notes to the Employment Rights Bill. And it's that point about the intention of the person who's compiled the list. And it's only a list which is compiled with the intention of being used to discriminate that it becomes an unlawful blacklist. So theoretically, if an employer was so minded and somehow managed to, let's say get hold of a list of members that had been sent to a workplace rep, maybe the employer has intercepted the email from the union's membership department or something like that, and has gone, we've now got the list of everybody who's a member of the union. Then if they were using that list for the purposes of discrimination, then it's debatable at best whether the blacklisting regs would capture that as an unlawful act, because that list isn't compiled with the intention of it being used to discriminate or to treat people differently in relation to recruitment or treatment. So the plan is that the bill is going to extend the protection to any list, irrespective of the reason why it was compiled. Now, again, these kinds of things, the nature of blacklists is that they tend not to be overt documents, they tend not to be terribly well publicised, and we don't necessarily know if an employer is actually using a blacklist, for example. So that can be a bit of a challenge. Will it make any difference? I'd like to think it would, but whether or not it does in practice, only time will tell. So, just to conclude, I think it's fairly widely thought amongst the commentators in this field that we're coming close to the end of the legislative process, the drafting, the creation of this Act of Parliament, which is of course still a bill, because there are some other matters which still remain to be settled. The thing about the guaranteed work hours, including a duty on the Secretary of State to have regard to seasonal work when making regulations. And there are other bones of contention between the Lords and the Commons. But the significant change is the move from day one unfair dismissal rights through to 6-month protection from unfair dismissal rights. And I know in previous webinars I've said that I don't really understand, I've never really understood why protection from unfair dismissal isn't simply a day one right. But I think I'm kind of, having listened to a lot of the commentary last week on the government's sort of what was flagged as a U-turn on the manifesto commitment to have day one protection from unfair dismissal, I kind of understand it now, the argument as to why there should be this initial period where employers can dismiss. And it seems to be this, that, you know, my previous employment experience before coming to work for the union was within the public sector. I used to work in the NHS. And having worked in the NHS, of course, NHS employers have, you know, large HR departments and, you know, very well established protocols and policy documents and all those kinds of things. There's a huge number of employers out there that are being run by people who frankly haven't got a clue about employment law, arguably about how to run a business, it might be said. And, you know, I think when we think about what the law says about, for example, a capability dismissal, there are a number of stages that an employer has to go through with a capability dismissal before they can fairly dismiss somebody. Now, if it's fairly obvious soon after hiring that somebody isn't really cut out for the job, then, you know, that employer who doesn't really understand capability dismissals is just going to get rid of that person. Now, yeah, it's just probably pragmatically 6-month qualifying period. Look, it's probably better than it could have been, because the talk about the light touch dismissal procedure during the statutory probationary period was going to be a 6 to 9 month period anyway. So practically speaking, it was going to be 9 months before you had the full protection. And now it's going to be 6. So that's got to be better, surely. Anyway, that's, I think, pretty much everything I wanted to say about the bill, about what's coming in the latter stages of the bill, the implementation of the bill. So yeah, let's see what comes, colleagues. This is the last of the current round of webinars. It's obviously the last one for this calendar year. And as I sit here in the boardroom in our Unite office in Leeds with the regional equality banner behind me, the eagle-eyed amongst you will have noticed that it's different from the banner that I sat in front of in the last two webinars. So I thought I would change it up a bit this time. What you can't see across the room over there is the Christmas tree. So, you know, we'll take this opportunity to wish you all a very Merry Christmas when it comes, and hope you all manage to get a bit of a break over the festive period. And we look forward to seeing hopefully all of you and all your friends in the new year on future webinars. As I said, we don't yet have any firm plans about what we're going to cover in those sessions. So if there are things you'd like us to talk about, please do get in touch and let us know. So thank you all, and goodbye.